Turning next to what happens after the claim and response have been processed, there is then a new phase in the Employment Tribunal rules under Rules 26 to 28. The judge considers all the documents and asks whether there are arguable complaints which are within the jurisdiction of the Employment Tribunal, and similarly whether there are any arguable defences within the jurisdiction of the tribunal. The judge can order either of the parties to provide further information in order to allow the judge to make that determination. The judge can make a case management order listing or a preliminary or a final hearing and proposing judicial mediation or other dispute resolution. I want to talk a little bit now about the dismissal of a claim or a response. Have a look if you're a claimant at Rule 27 and if you're a respondent, Rule 28. So if the judge considers either that the Employment Tribunal doesn't have any jurisdiction, this applies to the claimant only, or that there's no reasonable prospect of success, either of the defence or of the claim, then action can be taken in respect of all or part of the claim or response. What happens is that the judge sends written notice to the parties, giving reasons for the conclusion that's been reached. If the judge considers on the SIFT that either the Employment Tribunal has no jurisdiction over the claimant's claim, or, in respect of the claim or the response, that there's no reasonable prospect of success for all or part of it, the judge will then send a written notice to the parties giving the reasons for that conclusion. It'll also give the date on which the claimant or respondent's claim form or response form or part of it is dismissed, unless before that date the claimant or respondent presents written reasons why that should not occur, why the document shouldn't be dismissed. If no such reasons are received, then dismissal takes effect without more, and the response is treated as if it had never been presented, with the consequences in Rule 21. If reasons are received, the judge may permit the claim form or response or part of it to proceed, or fix a date for the hearing of that point, whether the claim or response or part of it should proceed. The claimant or respondent may attend that hearing and participate if they want, but they're not obliged to. If any part is permitted to proceed, then a case management order is made. Now, case management orders are very important powers of the tribunal, and you'll find the general judicial power under Rule 29. A case management order in particular may vary, suspend or set aside an earlier case management order where that's necessary in the interests of justice. And in particular, where a party affected by the earlier order didn't have a reasonable opportunity to make representations before it was made. It's in this context that practice directions issued by the President under Regulation 11 about the exercise of the powers under the rules, which I talked about earlier, will be particularly important. In relation to case management orders, if you want the tribunal to make an order, it's best, in my view, to apply sooner rather than later, and don't wait around for tactical reasons, because as a litigant in person, it's much better for you to get the issues defined early on so that you can work to those issues, and also to get the information that you need out of the respondent, or in turn, if they're seeking information from you, to get that information to them. So have a look at Rule 30. What the rules say is that an application for a case management order may be made either at a hearing or it can be presented in writing to the employment tribunal. But if the application's in writing, you've got to notify the other parties that any objections to the application should be sent to the employment tribunal as soon as possible. The employment tribunal may deal with it in writing or order that it be dealt with at a preliminary or final hearing. The use of the term as soon as possible emphasises the need for speed in responding with your objections. Remember that you've got a duty to further the overriding objective under the rules, and therefore, again, don't wait till the last possible minute, because that clearly won't be as soon as possible.